Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. This month we start with a new section, Brexit Watch. There are now less than 6 months to the planned Brexit date and things are starting to become a little clearer. Perhaps not the outcome, but the impact and the options open to us. The government issued a flurry of guidance notes on the 13th of September explaining its view on the impact and arrangements that it hopes to put in place if there is no deal. The Home Office has published a statement of intent about how an EU citizen or a non-EU family member of an EU citizen can apply for settled status. A toolkit is available on the government's website to help employers to increase awareness amongst their staff. Meanwhile, the Court of Session in Scotland has ruled that a reference to the European courts will be made to seek confirmation that the UK is still permitted to revoke Article 50. Force majeure clauses are usually included in contracts to allow a party to escape liability if it is unable to do something by factors outside of its control. A recent case, however, has confirmed an earlier authority that to be able to rely on a force majeure clause, the force majeure event must be the sole cause of the failure to perform an obligation. Where the clause also obliges a party to use reasonable endeavours to mitigate the circumstances, this will include an obligation to operate less profitably. The 2012 Court of Appeal case of AXA v Campbell concerned an exclusion of liability clause for misrepresentation in a business-to-business contract. This stated that to exclude liability for misrepresentation, the exclusion clause must specifically refer to misrepresentations and state that there has not been any reliance on any representation. Now, the court in a recent case that concerned the sale of Nottingham Forest FC allowed a widely worded clause to exclude liability for misrepresentation, even though it did not meet the requirements of the AXA decision. The court found that unlike the AXA case, the clause showed a clear intention to exclude other contractual and non-contractual correspondence by including such words as drafts and correspondence, negotiations and representations. The contract also included specific procedures for dealing with misrepresentations within its four walls, which helped to show that the parties intended not to litigate any misrepresentation claims. Of course, it will be good practice to pick up the points raised in both AXA and Nottingham Forest when drafting such clauses. Another recent case also delved into misrepresentation laws. This case concerned a fraudulent misrepresentation. Following a precedent from an earlier case, the court found that where there has been a fraudulent misrepresentation, the wronged party only needs to show that the misrepresentation was one factor in its decision on whether to commit to the contract and that it might have made a different decision but for the misrepresentation. Now, this can be contrasted with a negligent misrepresentation where the wronged party would need to show that but for the misrepresentation it would not have entered into the contract. The Law Commission has launched a consultation on electronic signatures on contracts. The consultation closes on the 23rd of November. The Commission's provisional conclusion is that electronic signatures are valid, except for those documents that still specifically require a wet ink signature, such as deeds and wills. A recent report has revealed that only a third of UK businesses are insured against information security breaches, despite annual losses from cybercrime estimated to be topping £291 billion. There is often a misconception that a company's business interruption insurance will cover cyber risks. On the 8th of September, the Privacy and Electronic Communications Regulations was amended to obligate companies marketing claims management services to only make marketing calls where they have the consent of the consumer. Previously, people had to opt out of receiving such calls by registering with a telephone preference service or withdrawing their consent while on the call. The Court of Appeal has given a landmark decision on litigation privilege in the case of SFO v Eurasian Natural Resources. This decision overturns the High Court ruling and will allow companies that are investigating disputes or alleged wrongdoing, in most cases, to use litigation privilege to protect those documents from being disclosed to others. The Employment Appeal Tribunal, the EAT, has held that a lawyer's email that advised how redundancy could be used as a cloak for dismissal of an employee was not privileged and must therefore be disclosed. This decision follows established public policy that a party cannot enjoy the benefit of legal privilege where the relevant communication furthers the iniquity. In a recent Barclays Bank v Various Claimants case, the Court of Appeal has reaffirmed that the independent contractor defence no longer exists, so organisations may be liable for the acts of third-party contractors where the contractor relationship is akin to employment and the act complained about is closely connected with that employment. The Barclays case related to a doctor who was engaged as a contractor to undertake medical examinations and where it is alleged that assaults took place. The Business, Energy and Industrial Strategy Committee has published a report on gender pay gap reporting. The report contains recommendations to tackle gender pay gap, including introducing performance indicators for reducing and eliminating pay gaps. HMRC has issued an update stating that where there has been a TUPE transfer of employees, all national minimum wage liabilities, including penalties, will be enforced against the transferee employer. In Talon Engineering Limited versus Smith, a dismissal was found to be unfair where the employer refused to postpone the hearing by 10 days to allow the chosen companion to attend. The Employment Relations Act of 1999 gives workers the right to be accompanied by a fellow worker or union official to all meetings that may result in disciplinary sanctions. The employer must agree to a reasonable alternative time requested, providing it's within 5 working days after the date originally proposed. We have previously reported the CMA's fine to Ping Europe Limited of 1.45 million for breaching competition law by prohibiting 2 of its retailers from selling golf clubs on their websites. Ping appealed to the Competition Appeal Tribunal, the CAT, claiming that the website's sale ban was in the interests of consumers as it wanted to promote custom fitting. The CAT disagreed and has upheld the CMA's decision, except for some minor changes to the calculation of the fine. Thank you for tuning in for this month's commercial bulletin. For more information on any of these stories, please contact me or any of my colleagues at Radius Law. We'll be back in November with more of the month's key legal updates.